Good afternoon and welcome to the Beverly Hills Bar Association NFT Week. Thank you for joining us for today's panel that we call The Legal Minefield of NFTs. The Lawsuits Have Begun. I'd like to start today's panel by introducing our esteemed guests, legal experts in this field. The first is Jeremy Goldman. Jeremy Goldman is a partner at entertainment and media powerhouse Frankfurt, Kurnit, Klein, and Selz PC, where he has been litigating cases and counseling clients on novel issues at the intersection of intellectual property and technology for 15 years. Jeremy founded and co-chairs the firm's blockchain technology group, combining the firm's deep technical knowledge of Web3 with the firm's unparalleled excellence in IP, entertainment, media advertising, video game, consumer protection, intermediary liability, and privacy law to help crypto native clients bring blockchain to the world and the rest of the world bring blockchain to their business. Above the Law recognizes Jeremy as an IP NFT pioneer, and he has been listed as a top IP and entertainment lawyer by Best Lawyers, Super Lawyers, the Legal 500, and Variety's Impact Report. Next, we have Jesse Saivar. Jesse is a partner with Greenberg, Glusker, and is the chair of his intellectual property department and heads up the digital media and technology practice group. Jesse is a reformed entertainment attorney who now focuses on providing outside general counsel services to digital media and tech companies whose products are built to entertain. Jesse has particular expertise in helping tech companies navigate deals in the entertainment world, such as talent agreements and content distribution and licensing. Jesse also frequently negotiates IP licenses, including in the realm of NFTs, and provides his clients with general IP enforcement strategy. Jesse hopes to one day be considered non-fungible. That's a direct quote. Last, we have Sean Sullivan. Sean is a partner in the LA office of Davis Wright Tremaine, LLP. Sean's diverse practice centers primarily around intellectual property law and its intersection with digital media and emerging technology. Sean counsels clients in the entertainment, gaming, and digital media spaces on issues revolving around intellectual property, licensing, utilization of the blockchain, and advertising and marketing, and litigates copyright, trademark, and trade dress infringement cases. Specific to this panel, Sean has worked with a number of companies on their NFT licensing deals, both from a licensor and platform licensee side. Thank you, panelists. We have a lot to cover, so we'll just get right into this fascinating discussion. As the title of our panel and the accompanying compendium show that we've made available to you, the lawsuits relating to NFTs in entertainment, arts, and sports have begun. The first question for our legal experts is, are there any unique intellectual property claims in these lawsuits relating to NFTs, or are the legal claims that have been brought so far all grounded in basic IP laws, such as copyright and trademark? Panelists?
Who wants to go first? And I think we were actually chatting about this right before we got on, and there may be some even disagreements among us. I think generally we're dealing with traditional IP issues in these lawsuits. I mean, I think the assets are somewhat unique. I think NFTs have created a market where there wasn't a market before, and that kind of confuses the question because it makes it feel like something is new. But at the end of the day, most of these suits, other than maybe the freeholding suit, I think really involve pretty traditional copyright and trademark issues.
Right, and I agree with that. I think generally speaking, when we talk about NFTs, it's not as if there's a new bundle of IP rights necessarily that have been created by virtue of NFTs. So we're really looking at the same laws. It's application of those laws and how they're looking at these use cases. That's, I think, where we're getting into some, and we will be getting into some more interesting features of how that law gets applied in this context, especially, you know, the one case where we talk about in terms of the freeholding case is the ownership issues and how those rights kind of flow. I think we're going to get into some additional points as it relates to coming down the line, the license structure and how that's all getting interpreted, twisted, and otherwise understood.
Do you want to give just a little summary of the freeholding? I know it's in the compendium of materials, but maybe one of you panelists will just, if we're going to talk about a case, just give a little bit, maybe a 5-second sort of summary of what the issues are or the parties.
Jeremy should probably, do you want your disclaimer, Jeremy?
Yeah, let me give you a good disclaimer. I do represent one of the defendants in the case, which is called Nameless. And for all the lawyers out there, this was fascinating to me. This is totally, we're going sideways already. Nameless does not have a corporate, like it's not Nameless Corporation. It's not Nameless LLC. It's just Nameless. And the reason why is because they registered in Wyoming, and Wyoming does not require you to have an appendage on your name. I thought that was very cool, but it does make it seem like every time I just want to write like Corporation, Inc., something. Okay. We represent Nameless in that case. So my comments on this are going to be just from me personally, Jeremy, and I'm just, I feel comfortable talking about it at a very high level, just in terms of the allegations. I'm going to try not to opine in any way, shape, or form on the merits of the case. But in the freeholdings case, you have a person who's using freeholdings filing a lawsuit against an artist, Sotheby's, and my client, and there was my client Nameless, and there was one other person. And the allegation is that Sotheby's a few months ago did a batch of sales in an auction and sold a number of NFTs that they were claiming that Sotheby's held out as sort of very early NFTs. And these were very early demonstrations of what an NFT is. And they sold as part of that lot, and as one of the sales was an NFT that was called the Quantum NFT. It was sort of promoted and described as one of the first, or the first NFT that had ever been created, and it was created on a blockchain called the Namecoin blockchain. And the Namecoin blockchain is sort of a outgrowth of the Bitcoin blockchain. And this occurred in 2014. I'm going to mention the date because 2014 is a year before the Ethereum blockchain was even launched. So this is pretty early. We're definitely over our skis here in terms of sort of like assuming people's knowledge level. So I'll rewind just a little bit to say there's lots of different blockchains. There's not one blockchain. The two most famous, largest blockchains are the Bitcoin blockchain, which predominantly, like very predominantly, has been used to buy, mint, sell Bitcoin, right? That Bitcoin cryptocurrency. And Bitcoin currency is all fungible. One is the same as the next. Namecoin was one that was kind of like a domain name registration type system. An artist named Kevin McCoy created a token on the Namecoin blockchain that had a link to a piece of artwork that he uploaded to a server and put that on the Namecoin blockchain in 2014, and saying that this is really the first NFT where you had sort of an entry on a blockchain that was linked to a piece of artwork that was stored elsewhere, which is very similar to what's going on the second most famous blockchain, which is the Ethereum blockchain. In this sale, what McCoy, the artist, did was they minted a new Ethereum NFT. They minted a new token that quote wrapped the Namecoin NFT and said, this is now sort of the record that's signifying that original NFT from 2014, but instead of selling it on Namecoin, which isn't used very frequently, we're now going to sell it on Ethereum and put this out there into the world, saying this was the sort of the first NFT. This Freeholdings came out, and Freeholdings, the individual goes by Early NFT, came out and said, not so fast. What he alleges is that the Namecoin NFT had a requirement that you renew the registration, similar to what happens with domain names, right? When you buy a domain name, you have to renew your registration, or even like a trademark registration, right? You have to renew your registration every, any number of days. I think it's like less than a year, 270 days, something like that. And what he alleges is that that the registration had not been renewed, and that he jumped in there and grabbed the registration. And so therefore, it is not correct that Kevin McCoy is the owner of this NFT. Again, I'm not going to opine on the merits of this. I'm skeptical, I'll say that, but I do represent one of the defendants in the case. So there's this lawsuit now, and in some ways, this lawsuit really does raise this question in a unique way of sort of, what does an NFT signify? What does it mean to own an NFT? How does that intersect with the various metadata and records that are associated with an NFT? And should this case sort of go the distance? I think it could be very interesting to see how the court examines all of this.
Right. And just, sorry, I was just going to tack on to the point of being somewhat over our skis. I assume most people who are listening in by this point in the NFT week know what an NFT is, but just the concept, I think, as Jeremy did a great job of explaining what the various blockchains are that are out there in terms of an NFT, and how it relates to the data that's associated with it, I think is a key kind of concept in all of this in terms of how we look at it, which is there's a token, which resides on a blockchain. As Jeremy described, there are many different blockchains, or a few different main ones that people tend to mint NFTs to in particular. It's a token that is just identified by a hash, a string of numbers, identifiers, and that is associated with some other asset, whatever that might be. It could be a physical asset, it can be a digital asset. What we're talking about primarily are digital assets that reside somewhere else, typically on a cloud-based server of some type. In many cases, the interplanetary file system, but not always and not exclusively. And it can reside on any cloud-based server or elsewhere. But there's an association between the two. And most of the suits we see that are out there deal with the data, the actual, whatever that file is that's associated with the NFT. And that's where we get into these debates over intellectual property rights, or with respect to the data. This suit's a little bit different and is really interesting in that regard because it's dealing with the token. And that's something that we don't see in many of these other suits.
So maybe you guys can now talk a little bit about the Tarantino case, because I think that sort of talks about the IP rights, which is one of the focuses of the panel today.
I mean, I think to go back to freeholding for one sec, what's interesting about that is we haven't really talked about the image that's involved in that NFT. Sean mentioned that it points to data. I think for laymen, when they think of NFTs, they think of the images that are associated with those NFTs. And the freeholdings case really doesn't get into that. It doesn't get into ownership of the image or the right to display the image. It's really about the underlying NFT itself, which makes that kind of an outlier. Contrast that with, if we move on to the Tarantino Miramax case, like most of the other NFT cases that we're discussing, it really is more about the image there. And in that case, the image is, a picture of the original Pulp Fiction, a page from the original Pulp Fiction screenplay. And the question is, does Quentin Tarantino have the right to sell an NFT, which provides the purchaser with certain rights to that image? Miramax claims that he doesn't have that right. Quentin Tarantino claims he does. But I think this case it goes to that first question. Are we talking about something very unique here because it's an NFT, or are we really just talking about IP law? Here, I actually think we're really talking more about contract law. For those who are unaware, when Quentin Tarantino optioned his rights to Miramax, they acquired any and all rights other than certain reserved rights. And one of those reserved rights that Quentin Tarantino kept was the right to publish, publication rights in the original script. So think about, he would have the right to sell copies of his script through a bookstore, let's say. And so the question has become, okay, with this NFT that involves a picture of the original script, does that implicate the publication rights or not? And that's really a fairly simple question. And it really doesn't, in my mind, the fact that it's an NFT doesn't really matter, other than it's gotten a lot of publicity because everyone wants to talk about NFTs.
Well, isn't it true also because it's going to be impacting all the major studios and film and TV productions are now looking to create NFTs. So people are following this case to see what legal rights they own from prior works, and is going forward, what would be in agreements going forward. And I know tomorrow's panel is going to touch a little bit on that, but from a litigator's perspective, I understand that that case is being filed for that reason. And the other thing that I found interesting was that the case it wasn't like Miramax reached out to Tarantino and they settled it right away before a lawsuit was filed. There wasn't a settlement and the case is still moving forward. There was an attempt for an injunction. So the Tarantino was allowed to issue the one NFT, which I understood was of 7, but I think it's at a standstill now. So I don't know what you all believe, but your opinion, what you think about that the case is going forward and there hasn't been a resolution yet. And I think there is some sort of monitoring by the legal community as to what is going to happen there and how are we going to handle this going forward.
I'm curious if Jeremy and Sean disagree with me, but I think what's kind of unique here is we're talking about an NFT that involves pages from a script. And so it's very specific to this case, and because it gets into the publication rights and whether it's a reserved right. Studios are obviously going to try to capitalize on NFTs, but I don't know how many NFTs are going to involve pages from a script. So the issues that studios have to worry about with those NFTs, I think, are slightly different than the issues in that particular
right
case.
And I agree. And I think part of the reason you see this case continuing on versus maybe some others that were threats that didn't actually get filed are the parties that are in play. I think Tarantino's always had a very strong view on this, especially with respect to that script. And I think facts make cases. This is one where I think ultimately the parties and the respective beliefs they have and the rights that they own is what's driving this. I don't know that this is going to be necessarily a case that it is going to be emblematic of future cases down the line, mainly because I don't think many parties had these types of carve outs. Of course, there's going to be a discussion of what was carved out, what was happening. But even in the most recent filings, there's discovery battles over some of the history of the negotiations and what's been reserved, what hasn't been. I think where we're going to get into some issues in the future with termination rights and what's going to happen there, those are going to drive some more suits in terms of an understanding of where those rights exist. There's going to be a concept of from all parties, an understanding of where the rights exist, who owns those rights, and how you can exploit them. And that's something I think we talked about in preparing for this panel, that we look at that's the first question I always have when a licensor approaches and says, what can we do with this? Is, okay, well, what do you own? And we have to look and see what it is that you own, so to see what you can exploit and in what manner. And so this is part of that deep dive exploration. It's going to drive, I think, a lot of probably Jesse and my work in terms of the licensing side. And then there's going to be litigation. I don't know that it'll be the exact type of litigation that we see in the Tarantino case. There's going to be versions of it. But go ahead, Jerry. You have your hand raised.
Oh, look at that.
Oh, I was doing that to let you finish, so I wouldn't interrupt you.
No, that's fine. You feel free to interrupt at any time.
No. So here's why I think that I agree with both of you that the narrow view and the technical view of this case is that it's just about interpreting whether this particular use is covered by a reserve right under the contract, and it's just a matter of contractual interpretation. But what I see the Miramax Tarantino case standing for is what I call a battle over the new third layer of the NFT copyright cake. And here's what I mean by that. Existing copyright law recognizes 2 layers, right? It recognizes that there's, and this is in sort of section 202 of the Copyright Act, very fundamental concepts of copyright. A copyright distinguishes between the material object and the copyright in the material object, 2 layers, right? You paint a painting and you have the painting itself that somebody can sell as a physical object, and then the intellectual property rights that are embodied in that work. which are retained by the artist. 2 layers, okay? And what is happening here with NFTs, and what is the copyright? So like, we know what the material object is. What's the copyright? The copyright is the bundle of sticks, and the bundle of sticks are the bundle of exclusive rights, right? That are captured in section 106, right? Those exclusive right to reproduce, to make derivatives, to distribute, publish. It's very defined. What is not in 106? What is not in 106 is the right to mint or control an NFT associated with the work. Okay, it's not there. It's not a copyright interest, right? It's not a copyright interest. It's something else. So what the heck is an NFT? An NFT is not, it's not the material object. When you buy an NFT, you do not get the material object. Like when I have a few NFTs. One of them is an NFT that sits on this interplanetary file system. I was never given any document or paper or anything that said I had any right to have a material object, even a digital object associated with my object. And I definitely wasn't given a copyright, because the copyright on this particular NFT project is issued under a CCO license, a Creative Commons public domain license. Like the artist basically said, anyone is free to use this NFT, the artwork for this NFT for any purpose. So I certainly don't have any commercial rights for this NFT, okay? So it's not the material object, it's not the copyright. What the heck is it? What it is, and I could have a slide that I could put up, but what it is it's just the right to edit a line in a spreadsheet, which is called a smart contract, right? It's a line on the spreadsheet that says that I am the owner of this token that's associated with this thing that has an artwork, and there could be intellectual property. I have the exclusive right to edit that line on the spreadsheet. No one else can. That is not an exclusive right that is in section 106. That is not, that's a new thing that no one cared about and no one ever valued before. No one put any value. All of a sudden, there's people paying like hundreds of thousands of dollars for the right to be associated with a piece of artwork. And somebody says it's a deed. Well, kind of. A deed actually gives you the right to go and have the house and to go claim and go to court and say, I get the house. That, with absent terms or absent other things, the NFT just gives you the right to be associated with this thing. I call it the third layer of the copyright cake. And what I see with the Tarantino case at a high level is just it's sort of emblematic of this battle where there's this new value created in the form of NFTs that just didn't exist before, and people that are going to be vying to exploit that value. And here I agree, like whether somebody has that right or not is a matter of contract, but I see Miramax just trying to flex and say, hey, we bought all distribution rights, all media here and after known, like we thought we got the whole kit and caboodle with you just having these very narrow rights. And Quentin Tarantino says, well, no, the NFT is coincidental. Like I have the screenplay rights, I can use an NFT to go and sell them. Totally agree, it's a contract case. But I just think there's a bigger question that is brewing of like, who gets those rights? And I could see that happening with existing contracts of like artists trying to maximize and get the most they can out of it, and distributors, licensees, producers, and the like that bought something saying, no, we have the right to exploit that very valuable thing.
And I guess just to push back a little bit on this notion, because I live and breathe a lot on the blockchain space as well, but in terms of that copyright interest and what we're talking about, in my mind at least, it's no different than saying, well, in each and every iteration, a creation of a digital use of something, if we were talking about these rights when we talked about, okay, well, when we were stamping DVDs and we were making DVDs, did we create a new copyright interest, a new copyright right? No, we didn't. It's a new way of recording, perhaps, and an NFT is one step removed from that. Even in my mind, it's a tie to. I understand the concept of the token and the ownership of the token, but really, what you're getting, and in most of these cases, all you're getting is a limited license to the image that's associated with it. It's in my mind at least, it's no different than a lot of other applications where you look online. I know there's room for disagreement on this, and I throw it out there for that reason, because I think it's an interesting discussion on how we conceptualize this. Right. Because I do think the token aspect of it can add some interesting overlays in terms of how you're conceptualizing ownership and what it is you own, and what it is you're being granted a right to. But I think there's room for argument on both sides. And certainly, you know, I would say that there's an argument to be made that all you're getting is a limited license to that image. The recordation of the ownership of that image is certainly, you know, imprinted on the blockchain, however you want to conceptualize that. I say imprinted for ease of understanding. It's recorded on a digital ledger, but the token itself, and if we want to talk about the novelty of the token itself, we can do that. And certainly there's novelty there, but I don't know that that's an independent copyright interest that's being granted to you.
Yeah, I mean, I think I'm on the same page with Sean. I kind of see it as, you know, you talked about the bundle of sticks, Jeremy. To me, I kind of, and maybe this is oversimplifying it, but I see NFTs as kind of two things. One is a set of rights around the image that's associated with the NFT, and then essentially kind of a certificate of authenticity on steroids. And so when you're buying it, you're getting a certain set of rights to the image, which in most cases these days is a very vague and nebulous set of rights, which is part of the problems that we'll get into later. But I think you're theoretically getting a set of rights with respect to the image plus, you know, certificate of authenticity. So I wonder, I mean, I ask you, Jeremy, if Quentin Tarantino instead, if there was a market for this and Quentin Tarantino said, you know what, I'm going to take a photo of a page from the original script, and I will email you the JPEG. And I will also, you know, as part of that email, it'll obviously be from me. And I'm going to give you certain rights to use that image. You can put it up on your website. You know, I won't send a takedown notice. You can use it as your profile picture. I'll give you this set of rights to that image. And I'll also let you show the world this email that shows that it's from me. Is that, you know, any different than selling the NFT?
I think that, yeah, I do think it's different than selling the NFT. And that's what I'm trying to say is I really do disagree with both of you that what you get with NFT, I think that you're importing like IP concepts that I understand that existing IP concepts onto something that's not that, because I don't think, like with my example, like I own this thing called an MFer, right? Everyone has the right to display it. I don't have anything specific to me that gives me a right to display this any more than anyone else.
So there was no purchase terms or terms.
Nothing. It's just, and it was, by the way, it's not just with this. Let's say CryptoPunks. Oh, nice, Jared. You know, like with CryptoPunks, and we can talk about what that is. That's like the granddaddy NFT project. And until 2 weeks ago or 3 weeks ago, when there was a big merger of, you know, the proportions of like, you know, DC and Marvel basically merging, but we could talk about that in a moment. But CryptoPunks issued in 2017, not any word about what you get with the CryptoPunks, right? When you buy an NFT. I think the suggestion that like the value of an NFT, you tying it to the right to download an object or the right to access an object or view an object is really missing the point. It has nothing to do with that. It's not about that.
I don't think that's why people are buying them.
They're not buying them because they get to view them, or just maybe it's like to have the like an association with this thing that I can now put as my profile pic, but it's not, has nothing to do with the any of the copyright interests that are in that bundle of sticks. It's a
maybe you all can comment on, there's a comment in the chat that I find sort of applicable here, is that they're talking about the issue where a group bought Dune for 2.66 million euros, thought they owned the rights to Dune, produced an animated series, and apparently that is not the case.
No, I mean, that was a sort of ridiculous thing. I feel like I just can't even believe that's real. Let me ask this. Let me ask this, Jesse. Let me ask this, Jesse and Sean. Like, let me ask this. If somebody uploads, let's say just whoever did it, anonymous, uploads to IPFS, okay, a digital file that doesn't, okay, they just uploaded a piece of artwork, and then somebody else issues an NFT, does not display the NFT that's on there, does not do anything. All they do is link to it, and they sell it and say, I now have the NFT associated with this artwork. Is there any active copyright infringement there?
I mean, if you end up displaying it.
No display. It's
There's-
the display. The display is, the display is up there on IPFS. They don't even display. They don't even inline link it. They just create an NFT on a blockchain so has metadata on it that's linked to the IPFS file that exists. Okay, and they sell it. Like, is that a copyright infringement?
Well,
Go ahead,
Sean,
Jesse.
go for it.
I was just going to say, the only way that I could see any sort of argument for infringement there is if they inhibit any of the exclusive rights. So for example, if that digital file that's uploaded to IPFS is the sole file that exists, and there's no other way to access it any other way, and by locking it, quote unquote, locking it down, applying an NFT to it, no one else has the right to view it, display it, or reproduce it, including the original creator who, theoretically in that example, still owns that copyright. Could you have an infringement argument there? Potentially. But outside of that, if all you do is own the NFT without, trampling on any of those other exclusive rights, the exclusive rights that are in the Copyright Act, then no, I mean, there isn't an infringement. But in order to show what you own, unless of course you create a copy on your system when you look at it, when you incorporate the NFT, because I know I own a few NFTs as well. And just by virtue of viewing it, I'm creating copies to a certain degree, right? So there are arguments there and teasing around the middle, I get your concept, but.
Right, the point is, you don't need it. My point is, you don't, why should I think that an author shouldn't have to go prove that one of the exclusive rights of copyright was implicated in order to have the right to be the only person, the exclusive right to do this NFT thing associated with the artwork.
That's the Hermes case that's in the compendium. Maybe we talk about a little bit. So that's a case where someone created an NFT based on the Birkin bag, and Hermes found out about it and brought a copyright lawsuit. Now, the defendant's defense is that they're an artist and they're entitled to protections of art. Where do you guys fall out on that?
And so since these two carried the heavy load on describing the other cases, I'll carry a little bit of load on this one.
Thank you very much, Sean.
Just as an intro piece, I think it's that one's more of a trademark case, trade dress case than it is copyright. And the arguments there are twofold. I think one of which is more interesting to me, another of which is I think attendant to a lot of different sales that you'll see out there with merchandise. But the concept being the defendant, who describes himself as an artist and who Hermes describes as a merchant, it had created what are called meta Birkins, which are effectively digital images of Birkin bags that have fur on them. And that fur concept, the fur coating on these meta Birkins, is critical from the defendant's perspective because he's purportedly a vegan, very strong into animal rights. And the reason that he created these meta Birkins depicted in this fashion was to create a commentary on the Birkins that you're, built primarily with leather and all sorts of other animal products built into it. And the commentary on, look, this is something that I'm creating that's a unique piece of art that is a commentary on what Birkins does and what they have in terms of sale across. Is the artist making money? Of course they are. I mean, they're selling NFTs, and the argument on the defense side, and they actually just filed their motion to dismiss, which is a good read. I mean, they had previously done some letter briefs on it, but they filed their now motion to dismiss, arguing under the Rogers Viper-Maldi example, the test there, that this is no different from any other artistic expression. It's a use they're making of the bag and putting it forth in an artistic expression and fashion so as to create a commentary on it. Birkin has responded, and they haven't responded yet, but in their complaint and in some of the letter briefing back and forth, one of the other arguments they make is that by using Birkins in the name, by using it in meta Birkins, that's also an infringement of their mark, their Birkins mark, and you're associating it with them and creating in the minds of your consumers a false association with the brand. The defense side, I think put forth a pretty strong argument there too, to say that, well, you do that and that's permitted in a number of different cases in the merchandising context. When you're creating an artistic work, something that's a commentary piece, you have to be able to refer to the original work and whatever it is. So by using Birkins in the name, they're creating, again, commentary on what it is, the original kind of product that they have created this object in. Where it gets really interesting, and something that's been alluded to in the briefing, is this argument by Hermes, and I know I'm pronouncing that incorrectly, but I don't have it. So Hermes or me, whatever, whoever is more into fashion can correct me. But the argument that they have made, at least in some of the back and forth correspondence, which is that these NFTs will get integrated into other metaverses and other universes. And so that takes it out of being just a work of art and something that becomes more of a commercial product, something that someone in some metaverse, some Web3 application somewhere is going to be carrying a meta Birkin. And guess what? That takes it outside of being just a piece of art that you put up on your wall or that you otherwise can show. Again, I think the defense did a pretty good job of undercutting that argument in their motion, but mainly pointing to the fact that, look, this is theoretical. The concept is these are just being sold as works of art. And this works of art concept underlies a lot of kind of what we look at, both from a trademark perspective, but also from a right of publicity perspective. You're going to get into some of those arguments too, as to whether or not it's a work of art, something that is more akin to a limited run poster. And there's some cases in New York on those protections for limited run posters versus something that's going to be more ubiquitous, something that's going to be launched in grand fashion with, just basically merchandising. You're just stamping a bunch of t-shirts and selling them, as many as you want.
Yeah, I'm fascinated by this case. And I think that at its core, the question is this really a work of art? And, I think, the bar is pretty low for determining what a work of art is. A greeting card is considered an expressive work. A t-shirt can be an expressive work. When I look at this, just my gut reaction is, I don't think this is a work of art. And I think that the reason I feel that way is Hermes may not be offering virtual bags in the metaverse right now, but it's certainly something that's going to happen in the future. And I think that the people who are buying these are not buying them because they like the work of art and they like this, message that he's supposedly conveying, which, when I read it, it feels very manufactured, that message. And maybe I'm just cynical. But I think that, to me, it feels like a traditional trademark issue. Like, I think your average person would see this Meta Birkin bag, and even though it's not a real bag, they're going to think, hey, this is the virtual version of the real thing. This is something that, like in the Nike case we might talk about later, Nike goes right out and says, look, every brand is going to have virtual products.
Why don't we go ahead and talk about Nike? Because I think it does sort of touch on this. Thank you. You want to give a little intro to that?
Jump into that one. But I just, last thing on the Hermes case, I think it's interesting that, and we didn't mention this, but the same artist originally put out one single NFT that was called Baby Birkin. And it was a more detailed image that had like a fetus in an Hermes, in a Birkin bag. And to me, that felt like art. It was a one-off. It had, I don't know what the commentary was, but it felt like some commentary. Like, I don't think Hermes would be putting out images of fetuses in their bags. And so, and Hermes didn't object to that, even though he used a Birkin image, he used the Birkin name. It was when it turned into 100 of them, and they looked very much just like Birkin bags. And I think the people who are buying them for the same reason people buy Birkin bags, which is, hey, I'm like in this exclusive club who bought something very expensive. I don't think that people are buying them for the artwork.
Let me just say one comment about that case, but more sort of like high level. What I think is, and this is more in line with what Jesse and Sean, what you both are saying, I think what's great about the NFT thing for IP lawyers and entertainment lawyers is that it's just accelerating all of these use cases, right? Like, all of a sudden we're going to have all this appropriation art, all of this like parody, commentary, art. It's just like, there's just this
Right.
new market for digital art, and there's all these creators that are jumping in and trying to do really cool stuff. Some of it's like on the line, over the line, you know, and courts will be able to sort it out. And in that regard, it's not any different. Like the Meta Birkin case, it's interesting that there's this metaverse element. I think that makes it really interesting. And it's interesting, but it's just interesting as an IP case in and of itself. It doesn't have to be that it's an NFT. It's just a really juicy case. And why did it come about? It's because of this explosion and this new marketability for digital assets that just didn't exist before. You know, you have like a good appropriative art case once every year or 2 years when Richard Prince decides to do something, or somehow Andy Warhol is back on everyone's radar with like an ancient piece of artwork. Like now there's a lawsuit in the Supreme Court nonetheless. Like with these digital art having such value, now there's reasons that artists are going to sue over it and say, hey, you're infringing my copyright. Whereas before there just wasn't as much of it. So I like it for that reason, just so much activity. And so we're going to get lots, and right of publicity, like, man, I can't wait till there's like the celebrity NFT, like trading card, and is, you know, like all these cases, just not a lot of law on it. And I think this is going to push it, hopefully going to push courts to issue some good decisions and get some good certainty in these areas.
Yeah, and to your point, just building off that point, not only are individuals going to be pursuing these individual artists, but the brands are, as we see now, because they're going to want to stake. They see some stake here, and the dollars make sense to them. So they're going to pursue cases that they wouldn't have pursued before. So you're right. I think there's going to be more here, and there's going to be more development in the law as a result of that.
It's like a lot of the law was, like copyright law is developed by pornography. All right. So the reason why is because, it's like the only time somebody would have paid for a digital image is if there's naked people behind it. Right. And so Perfect 10, like, and then Playboy before it were responsible for actually bringing lawsuits for copyright infringement because there was a commercial value in exclusivity over these image rights. Now with NFTs bringing new value to digital images, you now are going to have an onslaught of copyright litigation because they're actually have monetary value and they're worth litigating. And so it's kind of like for the same, it's sort of analogous in my mind.
So maybe jumping from Playboy, we can go ahead and talk about the Nike shoe case.
I mean, I think it's similar to the Hermes case in that I think the fundamental issue, it's slightly different. In the Hermes case, is it art? Is this NFT, art, or is it a commodity? I think in the Nike case, the question is more, is the NFT really a certificate of authenticity, or is it a commodity? And so I guess I'll just summarize the Nike case. It's, there's a company that has a resale market for rare shoes and other products. And they sell a lot of resales of rare Nikes. And they are now offering NFTs. And correct me if I'm wrong, I believe you don't even get the pair of Nikes that you buy. They're in a vault somewhere. So what you get is an NFT that displays the Nike name and image that indicates that you own this pair of shoes that's in a vault somewhere, which, for many of us, it's just kind of mind-boggling. But there's a market for that. And, Nike's argument is that, hey, the asset here is really the NFT. You're allowed to resell Nikes, but what you're really selling here is an NFT. And it is infringing our rights, our trademark rights, because people are going to associate that NFT with our products. They're going to think that this is a Nike associated NFT. And I'm blanking on the defendant.
StockX.
Yeah, StockX. Their argument is, hey, this is all it is essentially a way to authenticate the purchase of a real product. I think where StockX is in trouble is the way they've marketed it. It does not feel like they're marketing the NFT as just kind of an ancillary benefit to buying the actual shoes. They're calling it an investable, an investable asset. They're associating additional benefits with the purchase of the NFT. So it really does feel like they're just selling an NFT, and the shoes are kind of ancillary.
I'd like to, yeah, go, sorry.
The price for the NFT has risen above the secondary market price for the same shoes, which shows that there's got to be more than just shoes involved here.
Sorry about that. I just was going to raise a question that came from John Baldiva, who's one of our esteemed leaders of the entertainment section here. And it's an interesting question because this, I know it came up in the Tarantino case where there was the sellers were sort of questioning if you bought the NFT, in particular the Tarantino one, what would then, did you yourself have exposure because there are claims against it? And John's question is, if an NFT is purchased and sold on a secondary market and is later ruled that the original creation of the NFT is infringing on the right of another person, are all the subsequent sellers who would otherwise be bona fide purchasers, can the secondary market sellers be held contributory liable for the subsequent infringements? And I was also thinking of somebody buying the shoe NFT from Nike. So interested to see what you all think. Thank you.
Let the litigators take that one. I mean, I think that dovetails into, I think the second part of our panel was going to be about, hey, what are some of the problems that we see down the road? What are the things that haven't been litigated yet? And I think this is certainly one. You know, what happens to subsequent purchasers who buy an NFT that's associated with infringing artwork? You know, I think there's all kinds of issues that come up. Can they be liable for copyright infringement for displaying it? What happens if that's taken down? Do they have recourse against the person they bought it from? I think there's certainly going to be those issues coming up down the road.
So I can't copy. This time I will not comment on the Nike case because I do represent Nike in connection with their Web3 work. So that one I will leave alone. But I will mention that in the free holdings case, the plaintiff did initially sue the purchaser of the NFT, who went by the name Silly Tuna, and there was a voluntary dismissal of Silly Tuna. I can't really talk about why. I actually don't know why, but that would have been an interesting thing as to whether there would have been a claim against Silly Tuna, who just bought this NFT, just bought the NFT. I'm skeptical that someone who just buys an NFT would ever really be, responsible for copyright infringement, unless, let me put a big caveat on that. Okay. Putting aside what I just talked about, when I was giving my sort of spiel about the third layer of the cake and talking about the naked NFT, I was really talking about just the NFT itself. When you sell an NFT, you can, of course, as you can with anything, you can attach terms to it and say you're getting other things in addition to just whatever the NFT is. And I'm saying all it is the ability to edit a line on a spreadsheet. That's really all it is. And the trend is now, and very strongly the trend is now, especially with the most popular NFT projects, which are these like generative art projects where you get 10,000 of a particular character. The trend is now that by buying it, you're not just getting the right to see the artwork or even the right to use the artwork for personal purposes, but rather the right to make commercial use of your artwork. You could imagine a scenario where somebody takes a piece of art and purports to grant a commercial license to that artwork, and somebody buys it and then uses their NFT. It uses the artwork for a commercial purpose, thinking they have a license to do so because the person told them they do. The real artist comes out of the woodwork and says, hey, that was not, hey, NFT seller, that wasn't your license, that wasn't your artwork to grant. And they can absolutely go after the bona fide buyer who thought they had a good license, and it turned out that they were defrauded. And unfortunately, in that situation, copyright infringement is a strict liability claim. It doesn't matter whether you intended to infringe or you knew were infringing. It might matter for determining statutory damages. It might matter in assessing whether you're a willful infringer. But in terms of disgorging profits, in terms of getting damages against the person, the copyright owner would have an action against them. So that's sort of one thing that I could see happening. And I think we should talk about the problems, and I'll pause for Jesse and Sean to set up the secondary market, some of those issues. And the other thing that I think has what we've talked about, as a practical matter, as a lawyer working in this space, these are often collaborative efforts. And usually what you have is you have a platform or you have a service provider that's working with an artist. And that service provider or platform is going to be the one that actually mints the NFT and actually sells the NFT. And what we typically put in those kinds of terms is we try to make clear that the artist, one, is representing and warranting that they own all the rights to the artwork, and they're indemnifying the service provider in the event that somebody down the line, buys the artwork. It could be the primary seller, it could be the secondary seller. And then they could sue the issuer, they could sue the service provider saying, hey, you said that this was, at least impliedly, if not expressly, were representing that this was valid chain of title, that you own the rights. Now that it's come out and there's been a DMCA notice taking down the artwork, and now the artwork is sort of dislinked from it, I'm damaged, right? Like the value of my NFT is now zero or is negligible, and I lost that value, and I'm going to sue the platform or I'm going to sue the original artist. And I think that would be a valid claim. And that's why it's very important to have language that, provides for representations, warranties, and indemnifications with respect to the artist, so that should that scenario arise.
Worth those, in some instances, worth as much as the paper that it's written on, but hopefully more than that. It depends on who the licensor obviously is in that scenario. But yeah, I mean, I think as you pointed out, from a copyright standpoint, of course, the purchaser can be liable if they're, violating one of the rights, if they're displaying the image. And they didn't have, ultimately, it turns out they didn't have the right to do so through the various grants that were given that weren't valid. And that's unfortunate, but we see it all the time. There's been an industry made of those types of suits from a photo perspective, right? Digital photos that are out there that people are using, and they get these suits, and the dollar values don't necessarily need to be high, but there's a lot of them. And there'll be innocent infringers, fine, but it'll be $750 per or whatever it is in terms of the amounts of the damages, and that can go higher if you utilize it in many different fashions. So yeah, if you just own the NFT and don't do anything with it, never display it, never do anything, arguable. If you put it up somewhere and you show that you own it and you list it and, hey, look what I just bought, potentially, even if you were innocent.
As a downstream purchaser, though, I think the chances of you being sued for copyright infringement are probably pretty low, just from a practical perspective. I think the bigger risk that you run is, if these things keep increasing in value down the chain, if you're the fifth purchaser of an NFT and you've spent $400,000 on it, and suddenly the link gets disabled because it's an infringing image, maybe you don't get sued for having displayed that image, but it starts getting taken down, and now you spent $400,000 on nothing.
And I actually think, given the values you just put out there, you're going to see some of those suits down the line, because much like we see in the counterfeit context, you have to start from somewhere. And yes, you can trace it back, but you need to understand who the original, you're going to go back up the line, so to speak, on some of these projects. Some are pretty identifiable and who the original artists are, the licensors, but that's not always the case. And you're going to have, especially the longer tail that this has, you're going to have examples of people going after the purchaser at the time and then winding back and figuring out how these transactions go. I mean, that's going to be an interesting concept too, because of the anonymity that sometimes goes into these transactions. Is how are you going to get up the chain to figure it out? To a certain point, we can all look at the chain. I mean, it's publicly available, but you better hire someone who understands what they're doing to interpret and walk through some of that. And then at what point was the sale invalid? Who was not communicating correctly in terms of the rights that were granted? And was it the original licensor, or were they stopped at some point and then it kept going from that point forward? So these are all interesting issues that are going to come up.
So you guys may have answered the second topic, but I'll just go over it again if there's anything else you think we need to add. But our second topic was, what legal claims have not been brought yet, but given what we see happening in the NFT space, what legal claims do you anticipate will be brought?
I mean, there's
all of them.
But that would have to continue on to the next day, but
I think yes, Sean mentioned one that there has not been a juicy right of publicity lawsuit yet. There is one in the packet. There is a right of publicity lawsuit, and it has all the hallmarks of something that would be the juicy case, but it's actually not, because that's really just about the use of a celebrity's name and likeness in connection with the promotion of an NFT.
Yeah.
What I'm looking for is a case where somebody, there's a few cases I'm looking for, and one is like a one-of-one celebrity photo, right? That's like is presumably would in the print world would be considered a work of art. I'm saying presumably because I don't think there's a decision that is directly on point, as crazy as that sounds. Like, you know, photographer, like fine art photographer takes a beautiful picture of Beyonce, sells it a one-of-one in a gallery, and then Beyonce sues and says, you violated my right of publicity by making a commercial use of my likeness by selling this piece of art. I think we presume, lawyers, I would ask Sean and Jesse, I think we think that's probably not a right of publicity claim, but I think also untested, and you can correct me if I'm wrong. I don't think there's a case directly on point. I'm very interested in seeing the corollary in the NFT world, like a one-of-one. And then I'm interested in seeing what I think is the extended use case, which is like somebody creates like either a single celebrity or multiple celebrity, like a trading card collectible type thing, where they have either one face, a generative like one face, or multiple celebrities that get sold as NFTs. That to me is something that I would also like to say. That's just one thing, and there's just a dearth of really good right of publicity law. So I'd be interested in seeing that.
I mean, we have some trading card cases, so those are the
Right.
interesting ones. We got the Aldrin case
Yeah.
in California, and I think you've got a case in New York also with respect to, I think it's the San Jose Mercury News case in New York on posters. So you've got some cases that touch on this, but no, nothing in the NFT world. And that to me is also very interesting, and especially with some of the use cases we've seen out there. And I won't speak to many of them just because I've been involved on some of them, but which involve minting NFTs based on pre-existing photo libraries and or covers for whatever it might be, whether it be magazine, newspaper, or anything else.
Let me just raise this one, and I think it should segue, which is, sorry, Jesse, you go first, and then I'll.
No, mine wasn't that interesting.
Here's the one that here's the scenario that I'm really interested in and I'm very focused on, and it touches on what the three of us were sort of chewing on before the panel. I think this cues it up, which is, like I mentioned, you have a lot of NFT projects now that are granting commercial rights to the owners of the NFT, granting commercial rights to the use of the artwork that is associated with their NFTs, right? So the Board Apes, we mentioned CryptoPunks. The second one is the Board Apes, right? Now you have like 10,000 pieces of art, and the tokens themselves are very valuable, and each one of those NFT owners also has commercial rights in their Board Apes. We're seeing a lot of activity, and it's exciting, of Board Ape owners who own the commercial rights in their apes going and licensing them for various uses, to be as part of an Adidas campaign, to be in television, to be in a music group, and to be in a comic. So here's one. We have a client that does a Board Ape comic book, and they get licenses from people to feature their apes in a comic. We get, easy to get the license from the ape owner, right? You get the license from the ape owner, and that they can put their ape in the comic. The question is, what happens when they grant that license either on an exclusive or a non-exclusive or a term basis, and then that ape owner goes and sells their NFT to somebody else, and that somebody else wants to work with somebody else? What happens then? To me, that's a very interesting question.
I think a corollary to that was what I was going to bring up is, it's such a new thing, and people got into it so quickly that the rights that are laid out in some of these purchase terms or terms of use are not very well thought out. And I think, no offense to the Board Apes folks, but that agreement that apparently governs the rights that you're acquiring in the image that's associated with the NFT are very vague, and it's not very clear who owns what. What does the purchaser actually own? There's something that implies they own the copyright. There's a question of whether that's even possible without a written signed agreement. There's a license, and the license is very broad. And I think that what's going to end up happening is we're going to have competing derivative works. And there's going to be a question of what the rights are. So I've got a project that's really interesting called the Real Metaverse for my client Invisible. And it's basically like an animated reality show involving several characters that are from different NFTs. So Board Ape, World of Women, and in looking at the agreements that govern the rights, it's not always clear whether we need rights from the issuer or the owner of the NFT. And that doesn't even bring into account the trademark rights. So copyrights in each character can be owned theoretically by the owner, but trademark rights have to be owned essentially by one party. And so, in the comic book, the Board Ape comic book, I'm curious, how are they using the trademark Board Ape? And is there potentially an issue that it's going to draw association without the necessary rights?
It's called Ape Comic, and definitely not because again, client. So no problem. Everything they're doing is perfect.
Right.
As it should be.
Oh, look, I think you're exactly right, though. There's those licenses. Well, I don't need to be critical of those licenses. They did a better job than CryptoPunks, which is they said nothing.
Yeah, they're better than
100%.
So, and they're better than most of them. But I think the issue of, to me, the big IP questions that are being raised by all of this from like more of a transactional than a litigation perspective. So sorry to do that, but it's really like you do have this a completely new paradigm, a new market for all of this. And so how do you maximize the value of the IP between like a brand or a mothership that issues NFTs on the one hand, then you have the individual, let's say 2,000 or whatever it is, owners of these collectibles or something more than a collectible. And in between that is sort of the community of those people, which is the other element that is a massive part of this entire phenomenon. And it's really, community is the secret sauce of NFTs. And, people are putting rights, holding rights at the mothership, people are giving rights to the community, and people are experimenting with granting all the rights to a community and having that community determine what they want to do with the brand. And I think there's an incredible amount of experimentation. And I think about those Brandesian labs we learned about from the Supreme Court and from law school for me, right? Where you have all these different, you had 50 states that can sort of experiment with what's the best way, what's the best policy, what's the best legislation, and you have them test it out and wind their way through courts. And then you can sort of federalize it, and based on those experiments. I kind of see a corollary here where you have all these NFT projects doing massive experimentation with IP, and it really remains to be seen what the best sort of paradigm is, what the best licensing structure, like, can you really trust like your average Joe or Jane to figure out how to license like IP rights and like to exploit it? Like, why would they have any idea how to turn something out of their artwork or to maximize IP? Does that really make sense? And so I think there's really, incredible opportunity for experimentation and growth as this morphs and evolves.
I think that's a great way to sum up today. So thank you, Jeremy. We're actually hitting an hour. Unfortunately, it's a fascinating discussion and we could continue on for several more hours, I'm sure. But I want to thank our panelists and I wanted to thank our listening audience. I'm sure this discussion will continue. And I just wanted to mention that the Beverly Hills Bar Association will be continuing its NFT week with the following events. March 30th at 5:30 p.m., the impact of NFTs on family law. On March 31st at 12:30 p.m., structuring and negotiating NFT and blockchain agreements. On April 1st at 12:30 p.m., tax implications of acquiring, holding, or selling NFTs. You can register for each of these upcoming events on the events page of the Beverly Hills Bar Association website at bhba.org. And as well, your CLE credit there was posted in the chat the link so that you are able to obtain that. So thank you again, everyone. Is there any more last comments, or shall we just close it for the day?
Do you know that my only last comment is I just came back yesterday from NFT LA. Which
I was there as well.
Oh, you were there?
So I didn't see you.
Yeah, well, I mean, I'm not surprised. It was massive,
it was big, massive. Yeah.
I heard it was nothing compared to what was in New York, which is like, okay, that's what people say.
Always.
But it's a bizarro world, people. It is a bizarro world. You have like these institutional entities like Warner Brothers with like, you know, a beautiful display with all the Batmobiles and like all the costumes from the Batman movies. Like you have Warner Brothers and you have these like counterculture weirdos, me included, I guess, that are there like doing these crazy art projects, very counterculture, very like anti-institution, like all converging. And it feels kind of like a combo of like a rave and like a tech bro thing. It's very strange.
Yeah.
Which I think is symbolic of what an NFT is. You have the art world and the corporate world sort of like
You know, and I'll just tack on real quickly and say, you know, it's exciting for me because like most of the people who are on here, I've been involved in blockchain for a number of years. And for the longest time, I defend off people asking me, well, what's it matter? What's it do? There's no real use case to point to, or not many, unless you were really plugged in and understood other things other than Bitcoin. So it's exciting to kind of see this growth, this kind of expansion into other areas, and frankly, more of an adoption of understanding. People get it now, although I still do a lot of these what are NFTs, but they're less less one-on-one than they used to be. They're much more in depth, like this one was. So I find that very fascinating. I find it interesting, and I think it's good for everyone to kind of keep that growth curve coming. So I enjoy it.
Wonderful. Well, thank you again, everyone. And we really enjoyed this topic and our discussion and your time.
Thanks, everyone.
Thank you.